On to AB-2098.
Thank you. This bill establishes that the dissemination of misinformation and disinformation related to COVID-19 by a physician constitutes unprofessional conduct. This bill focuses on the spread of this type of information in the context of the physician-patient relationship. The analysis discusses the challenges that the board expects to face if implementing the bill as drafted, including a lack of clarity on whether the board must establish both a departure from the standard of care and that the information in question resulted in patient harm. Further, the definitions of mis and disinformation may prove challenging for the board to prove. As a result, staff suggests a supportive amended position with amendments to strike subdivision B and to amend the definition of misinformation to connect it to violations of the standard of care. Happy to answer any questions, Madam President.
Thank you. Are there questions or comments from board members? Mr. Watkins?
Yes. Yeah, I just have a few questions and maybe a clarification. So this, I read the Nick Sawyer documents that was sent to us, and in that document, as my understanding is that, you know, in this bill, we work from the establishing a patient, a physician relationship that gives rise to what happens between the patient and the physician. And if there is misinformation or disinformation communicated between them, then it further states that we would then apply in our new amendment the standard of care. That's one scenario. The second scenario is that this bill does not cover is the scenario where that patient-physician relationship do not need to exist because the misinformation or disinformation is actually done on the airways and in social media. So the evidence is already there. The unprofessional conduct under Section 2234E says that misinformation is dishonest, so we could act upon that. So right now, in my understanding, without even this bill, we could act on misinformation and disinformation right now because it establishes that we have such a right? And I mean, I'm open to hearing the board's position on them. And my ask would be, in this computer window, that when we went into asking on the Section 2270, misinformation means false information that is contradicted by contemporary scientific consensus, contrary to the standard of care. And so we already have scientific consensus. Is it not then better to say scientific consensus to the extent where its dissemination constitutes not gross negligence, the stuff was removed, but unprofessional conduct? So it's the last part of it, the parts that we struck to add contrary to standard of care, which means we need an expert, whereas if we go to zeroing in on the unprofessional conduct, that we would be addressing it at its core. We're really taking it to the legal part of it, that we just have to establish unprofessional conduct, because standard of care is so fluid that it provides too many openings for not being, not really for public protection, in my opinion. So clarification is, first of all, in this bill, we only focus on the physician-patient relationship, which is okay, but we have another section that we say that we don't need a law for, that already establishes unprofessional conduct is happening, and I think more prolific online and everywhere else. So if we were to act, we can act right now. I think we have the authority to act right now, but we can seek advice on that. And just that instead of using the standard of care, which require an expert, we could just say that to the extent where it is disseminating constitutes unprofessional conduct, then we are already in the section of the law that governs that.
I'll let some of my maybe colleagues speak to the part of your question about kind of current practice. And but what I can say with regard to social media statements, if I understood you correctly, Mr. Watkins, was that was contemplated in an earlier version of the bill, which was amended out by the legislature in the committee that approved the bill. I don't profess to be a constitutional law expert, but there was a pretty good discussion in that committee analysis that spoke to recent Supreme Court decisions and the various factors at play with regard to a state's authority to regulate the speech of one of their licensees. And I believe then that committee decided that the most appropriate means would be to limit the bill to the physician and patient relationship, and to then avoid some constitutional challenges.
Just a couple comments from me. I understand the rationale, and I appreciate. I appreciate that there are legal restraints, but the fact of the matter is this bill does not address what the actual problem is, right? It doesn't address the fact that we have California licensed physicians who have intentionally spread false and misleading claims about a wide variety of things, right, including COVID-19 vaccinations. They're advocating for the use of unproven, dangerous therapies that actually are harming California consumers, and they're stoking fear in communities not only in California but across the country. So this bill, maybe this bill's not the vehicle. Maybe there are risks, if we enforce our laws. But the fact of the matter is we have California licensed physicians causing great harm in our communities, and we have to figure out a way to address that. And again, maybe that's the medical board's jurisdiction. Maybe it's the Department of Justice. With fraud and other, BMP 17200 claims that they can advance. But look, we're going to have to figure out how to address this. And I know it's coming up in the context of this particular bill, but yeah. I make that point because I feel so strongly about it.
And thank you. I'm as passionate as you are, Madam President, on this misinformation and disinformation. The challenge is I don't think this bill is the right bill. Right now, from the medical board perspective, we're addressing standard of care. Once we try to go after physicians about, speech that, may or may not be protected, that's going to be counterproductive to our mission. And that's what I'm afraid of.
There was a document provided, I think a couple of times, last board meeting, that addresses someone that actually addressed those constitutional issues that Nick Sawyer sent to, Dr. Sawyer sent to everybody. I just can't find it now because I was reading it and I don't know what I did with it last night. Here's the issue. Maybe I can get advice, because it's advice that I seek to address this issue, is do we have right now, outside of this bill, the law on our side to actually go and at least, it is unprofessional conduct if we hear somebody spreading disinformation on the internet or all over the place. Do we have the right, and maybe someone could write us a memo, maybe the AG's office, to actually pursue that, or at the very least, send out a letter from the board to say, hey, stop that. The very least, to send out one of those letters of advice. I think that in the absence of us not doing anything, this is just being exacerbated. And I'm speaking to myself because I was just in Africa, and I was dumbfounded to see how misinformation has spread in South Africa, where I'm from. And even though people, without getting into things, it was just astonishing. And since here in California, we are the standard bearers, I just feel a responsibility to uphold this side so that it perhaps can filter out to the rest of the world. It needs an example. And I don't say what I'm saying is, so my ask is just to ask for a legal position, a memo that the board can receive about, if we can, why aren't we? If we legally can. So that's my ask. As of the bill, I mean, I understand that patient-physician relationships, so I don't have any issues with that for that one context, but it's the other context that we may have power on right now.
So I'm just hearing a couple things. One is a broader outside of the context of AB-2098 that the board would appreciate having some confidential legal advice in the form of a memo that is distributed to the board members that speaks particularly to this, or specifically to the issue about what we can do under our current laws. So I think that would be helpful. So we'll take that offline as a separate issue. It is something that together with our legal counsel, Dr. Hawkins and I have spent some time talking to them about as well. So we'll make sure that the board has that information as well, confidentially under attorney-client privilege, that you can take a look at it. But with respect to AB 2098, I think that the staff's intent is to make sure that this bill doesn't make our jobs any more difficult, right, than it already is. I think that's the intent of staff's recommendations. And so, I mean, maybe we can refocus on that. I recognize I got us off track a little bit. Maybe we can refocus on that.
And just to add, the idea of the standard of care being connected to the misinformation definition that's a concept that recognizing Mr. Watkins' statements on that, but that's a concept that is familiar with the board. We deal with violations of the standard of care all the time, and our investigators and our our attorneys. So that was the idea there behind that staff suggestion, Mr. Watkins.
Clarifying question. Oh, I'm sorry.
Sorry. You see, I wanted to explore, is there another way that we could do it outside of, that fluidity of standard of care? I know I'm asking a lot, and I'm asking outside of the box thinking, but it was originally written to the extent of, and just something to explore. I'm just open to hearing if there's more creative ideas that puts us in a better legal position, because standard of care gets expert heavy, and then, it's fluid. That's all I can say.
I'm happy to make a few comments on this. Part of what staff wants to do here is have a law that, if challenged, will be upheld. Otherwise, why are we doing this? So we want the law to be upheld. We also want to factor in that things are changing in this arena all the time. And so if we tie it to standard of care, if there's new treatments, new types of vaccinations that come online, that's factored in at that moment in time where the alleged violation occurred. So there's very specific and careful reasons why we're making the suggestions that we are, and that the board's role is not to monitor speech in every context, but tying it to the physician-patient relationship was something that we felt would protect this law if challenged, and the board's role in regulating its licensees. It is a complicated area, and there's a lot of moving parts to it, so we do need to be careful.
Dr. Kanonateb?
Yeah, this is a really tough issue because we do want actually people stop giving misinformation about treatments for COVID. This was the way it came on both vaccines and COVID treatments. But at the same time, you got to remember that medicine is not a stable thing. It constantly changes. What is today considered to be experimental or even voodoo becomes treatment of choice several years down the road. So this is This is not as simple as we thought when this bill first came in. We said, oh, thank goodness we can stop these guys hurting people, because people believe physicians and they might follow those things. So we got to work with the author how that all those concerns are taken care of at the same time that the boards will have the authority to discipline doctors who are truly giving information which can hurt the patient. That's what we wanted. It's not just misinformation, which can be detrimental to their health.
Yeah, I mean, in my opinion, it's not just that they're giving information that is detrimental to the health, which there's no doubt that some of our licensees are doing exactly that, but they're also profiting off of it, right? Which I find particularly disturbing. And those are areas where I'm not sure the medical board is the right agency to target that sort of behavior. But to your point, Dr. Gnanadev, and Dr. Thorpe, you said it, we were talking I think during the panel meeting. I mean, a physician is one of the only professional relationships where when a patient walks in the room, they immediately trust someone they may have just met that instant, right? They may have just met that person and they instantaneously trust them. They, allow an examination of themselves. They tell them a whole bunch of information about themselves that they might not tell to others because of that trust-based relationship. And that's why I think that it's so important that we address this issue, right? Because when patients across the country, across California, hear from our licensed physicians that you should take this dangerous and unproven therapy for COVID, for whatever ailment, they trust that. And we somehow have to be able to intervene and take steps to make sure that patients and consumers in California have access to factual, scientifically grounded information, recognizing that those standards change over time, recognizing that in California, our companies and our residents are often those who are developing and on the cutting edge of new therapies. But for the sake of us all, we have to figure out how to address weaponized misinformation and disinformation that is fraudulent and that is intentionally targeting, those who we are entrusted to protect, and not just, jeopardizing their health, but frankly stealing their money as well.
And I think we can get what I'm sensing the board members want, and that is, for example, if someone makes a comment on Twitter or Facebook or through a bullhorn, but no one responds to that in the context of a physician-patient relationship, then it's out there. But as soon as that person, in the context of this trusted relationship, spreads misinformation to that patient, whether that patient acts on that misinformation or not, or disinformation, that's where we want to address this and be able to get access to those records and investigate whether there's a violation that can be substantiated and whether discipline is warranted in that context.
I think this is a challenging, issue. I'm not quite sure if AB-2098 is the right vehicle or the right thing. I mean, we're talking about two different distinct subjects, right? We're talking about the person in the bullhorn or is out on Twitter in the public sphere. It goes back to the old, yelling fire in the theater. You actually can yell fire in the theater. That is not illegal. It becomes a issue if someone gets hurt as they're exiting out. The Constitution says nothing about yelling fire in the theater. If someone gets hurt because of your action, that's the issue, right? And so it's really difficult to find that nexus in the public forum, one. From a patient-physician relationship, to me, the base is all about, did my advice go outside the standard of care and cause harm to my patient? This is what we do every single day, right? So that has not changed. I'm not quite sure how this bill is adding any extra protection to that physician-patient relationship. And I don't know how we can monitor those physicians. You know, my passion is the same with President Lawson. They're getting paid for misinformation, and it is wrong. I don't know how we monitor, enforce public speech. And what I'm afraid of is someone has a lawsuit, comes to this board, and someone really gets harmed, and there's no severability clause, and all of a sudden, you know, that doctor walks off free and the patient is still harmed. So
I do want to clarify that the board does not have to prove harm. So I don't want to have anyone in the legislature to add that as a requirement, and that's something we're trying to address in this as well. We don't want to have to prove harm. We don't in other instances. We only want to focus on whether there's a breach of the standard of care.
And one thing to add, and it's reflected in the write-up here, but I neglected to reinforce it in my verbal comments, is that one of the additional amendments that we are seeking is to incorporate the language that was in Senate Bill 920, which was introduced earlier this year, which would grant the board enhanced medical record inspection authority. That's a previously approved position by this board, so I don't know that it's a controversial matter before, you know, the members here. But that might, perhaps to your point, Mr. Brooks, provide, if that language were to be included into this bill as well, might give us some additional tools in order to, you know, more effectively investigate and prosecute these types of cases.
Yeah, as I said, I'm gonna vote no on this bill until we get an analysis from our counsel, because I think this bill is, there's a lot, we need all the information we can before we make an informed decision. So, thank you.
Yes, Dr. Thorpe.
Thank you. So I think that none of us want to have, we all want to oppose misinformation that is intentionally aiding our own pocketbook, intentionally, helping us make more money that we wouldn't have made otherwise. That I say we as a physician, and none of us want to have any colleague give information, intentionally give misinformation, so that you're intentionally giving information that you know is wrong and is not helpful. The problem is that there are people who, even in this environment of COVID-19, there are clinicians who believe that what they are advocating is good therapy, and is helpful therapy. And I think that's the real crux of the problem. Is yes, no one would disagree that we should not give misinformation that we know is wrong and that we know is with intent to harm, or with intent to deceive, or with intent to distract our patient from health, from getting health. But you're always in this, as Dr. Ganandev pointed out, we have this challenge in medicine, that medicine is always in evolution. It's always changing. And Dr. Ganandev and I have been practicing long enough to know that what we thought was good science when we began our practice a number of years ago, I won't go into how long ago that was, but when we began our practice a number of years ago, is not good practice now. And in fact, the whole pharmacy of medicine has changed in the last 40 years. The whole practice of surgery has dramatically changed in the last 4 years. So, there was a time when some of those people who were pioneers in those areas where we have changed for the better were looked at as outliers and not really weren't the standard of care specifically, weren't the standard of care. So I'm not advocating that we do anything different about this language, but I would just want to make a statement about being aware of the challenge of a clinician or a group of clinicians who are advocating for a position they really believe is helpful, but is not the standard of care. And it may be a leadership role, maybe in a research role, but we've got to be careful that we don't put ourselves in a place where we're so reacting to the current situation that we don't allow for innovation and improvement in medicine. That's all my only concern.
Dr. Thorpe, I agree with you that these issues aren't necessarily always black and white, and there are often gray areas, but there are also circumstances where our licensees currently are disseminating verifiably false information, right? And this isn't necessarily a standard of care. I mean, let's like use on the one extreme, you should ingest bleach to take care of COVID-19. Verifiably false information, right? And of course, there's everything in between, right? We have active California licensed physicians who are disseminating verifiably false information. Again, this is sort of outside the context of AB-2098, which I think the author's intent was to make clear to our licensees and to the public that dissemination of certain type of information is unprofessional conduct, giving us the ability to take action where we see it. We think, our staff thinks, that this bill can be improved to make clear right, what the standard of care is. And again, it sets aside some of these broader issues that I think we need to address. I think we need to have a conversation about how we address them, because it may not be through the Medical Practice Act. It may not be through our enforcement function necessarily in terms of taking a disciplinary action. Frankly, sometimes it just takes too long there. But I think the intent of this bill is to just make clear to the public that we can take action under these set of circumstances, even if, frankly, we already have the authority under the Medical Practice Act to do so where there's a standard of care violation.
Yeah, a law that gets enacted that the board is not effectively able to enforce will lead to a lot of frustration for, I think, probably all the parties involved.
Right.
So that was the key consideration of the board.
Are there additional comments? I know that this is one where there is some public interest in commenting.
I don't know, Aaron, if I missed, what was your staff recommendation on this bill?
So the staff recommendation is support if amended, and it's on the 4th page of the bill.
Okay.
One of the, so the first recommended amendment is to, include the enhanced record inspection authority, which the board has previously approved in our legislative proposals. I think that could go a long way in helping with some of these cases. And then the other changes are more technical in nature, striking subdivision B that would remove some of the ambiguity that we see in the law, in the proposed law, and then to change the definition of misinformation to align it with standard of care violations.
Do we want to move staff's recommendation before we take public comment?
Make a motion to approve staff recommendation. Support if amended.
Moved.
Second.
Great, thank you. All right, looking in the room, is there anyone in the room who would like to make public comment? All right, seeing none, Sean, if we could go to the WebEx, please.
Yes, anyone who'd like to make public comment on this bill, please raise your hand and type something in the Q&A window to get queued up for make public comment. First up, we have Christy Sepulveda Burchett.
Burchett of Educate Advocate. Can you hear me?
Sorry, Christy, when you introduced yourself, it got cut off. Please start over.
Oh, I'm sorry. Hello, I'm Christy Sepulveda Burchett of Educate Advocate. Educate Advocate is a statewide grassroots nonprofit organization that serves families with children with exceptional needs. On behalf of the families we serve, I'm asking the medical board to withdraw their support and either be neutral or oppose AB-2098. The language is too broad. There's no standard of care or contemporary scientific consensus on COVID. What was recommended in early 2020 for care is no longer standard of care for treatment such as ventilators. Families like ours that may be medically fragile need a range of options for care and treatment, and doctors who offer such should not be labeled as purveyors of misinformation. This bill has unconstitutional restrictions on free speech. Further, this bill's passage will cause good physicians, especially those who serve our families, to leave California. I ask you to support the good work of our physicians in our state and not side against them. Again, I ask this body to withdraw your support of AB 2098 and move to a neutral or opposed position. Thank you.
Thank you for your public comment. Up next here, we have Christina Hildebrand. Give me a minute to send you the request. Oh, there, he's in this list here. Christina, you should be seeing that request on your end.
Hi, Christina Hildebrand. Can you hear me?
We can. Please go ahead.
Great. Thank you. Christina Hildebrand from the Voice for Choice Advocacy. We are one of the main opposition on this bill. Oh, there was a lot discussed, and I'm thankful for all the board members for acknowledging that standard of care is fluid and that standard of care today is not standard of care tomorrow, and that we cannot cut out innovation. And that innovation is not standard of care today. This is something I've been saying to the medical board for years. So thank you for acknowledging that. It was wonderful to hear our doctors on the panel actually say that. So on this bill specifically, I ask you to withdraw your support and move to a neutral or opposed position. There was a lot said. It is unconstitutional. You cannot stop or you cannot prevent physicians, and this isn't even in the bill, but it used to be in the bill, from putting things out on social media, from using a bullhorn and saying things. That's our First Amendment right. We live in the United States. We have that right. When we get to actual patient care, this bill specifically says standard of care and scientific consensus. There isn't standard of care or scientific consensus on COVID. If we were talking cancer, it would be a different matter. But on COVID, we are still in an evolving process because COVID is evolving and the treatments and the vaccines are evolving. I wanted to bring up the first proposal of an amendment, which says that the board would be, it's basically SB 920, which you put forward. SB 920 would have allowed medical records to be looked at in the interim without a subpoena. That bill, you cannot request that as amendment. That bill was paused, halted, withdrawn because organizations like the ACLU was against it because it would have been unconstitutional and it would go against HIPAA violations. So I ask this board that you do not request that amendment, or maybe you do, then this bill would die anyway because that bill already died. I think we need to look at what this is looking at, misinformation. If a doctor right now, if this bill passed, if a doctor said to a parent, I don't think your 5 to 11-year-old needs a booster because they already had COVID, that would be considered misinformation. So, because it goes against CDPH, it goes against standard of care, it goes against what the CDC is recommending. But that's not something that should be taken as misinformation or disinformation. I think you need to look at the number of complaints that would come
30
in.
seconds remaining.
And even number one, you don't need this bill. You already have the jurisdiction to do it. It's not necessary. Number two, you need to look at the financial impact. We've been hearing all day yesterday and today that, the board is strapped for money. This is going to put in a huge number of additional complaints on little things like social media posts that you don't have the money to go after. We need you focused on the doctors that are doing true harm to patients and not going after these little bits and pieces that are going to be coming in as complaints. So I really ask you strongly to withdraw your support and move to a neutral or an opposed position. Thank you.
Thank you for your public comment. Next up, we have Nick Sawyer. Nick, you should be receiving a request on your end to open your mic.
Can you hear me?
We can, Nick. Please go ahead.
Fantastic. So I just want to make a few statements here. May I ask a question to start? How many members of the board have watched the video of Christina Lawson that was made about Christina Lawson? Can we have a show of hands of the board who actually watched that video?
Dr. Sawyer, just go ahead and make your public comment.
Okay.
You've got 3 minutes.
So the public comment that I want to make was, first of all, the Federation of State Medical Boards started this by saying that physicians who spread COVID-19 vaccine disinformation or misinformation are liable for having their licenses revoked. And I think that was very smart of them to do, because when it comes to the type of disinformation that is harming the greatest number of people, and the people that I see coming into my emergency department who are unvaccinated and otherwise should be, are the people who are receiving this disinformation about the COVID-19 vaccines. And so while I hear other people talking about how this is going to cause a problem for academic debate, what I want to remind you is that when it comes to the COVID-19 vaccines, there is no evidence that the COVID-19 vaccines have killed more people than COVID. There is no evidence that the COVID-19 vaccines inject nanoparticles into your body that the government is going to use to control you. And so, yes, maybe this bill will help, maybe it won't. But the California Medical Board has the responsibility to protect the public from this type of rhetoric, because we already have over 200,000 people estimated dead because of this misinformation, and I continue to see it. And it's really harming everybody on the front lines who are taking care of these patients, and it's harming the people that you have been appointed to protect. I thank you for your time.
Thank you for your public comment. Up next, we have Dr. Hannah Ree.
Yes, thank you. So this is Dr. Ree calling on behalf of Black Patients Matter. So certainly this is an important topic. There's a great deal of misinformation out there, but what I haven't heard from any of the comments was the fact that for minority groups, especially within the African American community, there are home remedies which are beneficial to alleviating some of the signs and symptoms associated with COVID. And as we know, the mortality rate amongst Black patients is significantly higher. And we attribute that to racism within medicine. The fact that most California physicians have never treated, either by choice, voluntarily, or by population size, have never treated a Black patient, let alone touched melaninated skin. So these remedies could possibly be considered misinformation, disinformation, but not within the Black community. So we would discourage the support of this bill because it is, we believe, race-based, in that it addresses the average white patient in the state of California. Thank you.
Thank you for your public comment. Up next, we have Dennis Cuevas Romero. Yes, you should be seeing that prompt on your end.
Yes, thank you very much. Dennis Cuevas Romero with the California Medical Association. CMA is a co-sponsor of the bill, and we support the author's intent in providing clear statutory framework for the medical board to pursue discipline against physicians that flagrantly disregard their ethical and professional responsibilities to practice medicine in the best interest of patients. CMA is interested in trying to thread the needle to get at what Board President Lawson talks about physicians that are flagrantly and clearly disseminating information publicly on COVID misinformation, on COVID. It is challenging, and that was laid out pretty clearly in the Assembly Business and Professions Committee analysis. It's still CMA's intent to try to thread that needle, although it will be challenging. We hope to work with the board and the legislature on doing that moving forward. We appreciate the board's support of amended position and look forward to working with the board and the legislature to address the language and making it more workable for the board. Thank you.
Thank you for your public comment. Up next here, we have Virginia. Virginia, you should be receiving that request to unmute on your end.
Hello, interesting to go after the CMA, who has more power than the medical board. I appreciate the doctors saying how fluid it is, because once again, hand washing in the 1800s was not viewed as standard of care. It took a century for hand washing to become standard of care. And the person who introduced it died of sepsis. Zantac, which was standard of care, was removed from the market. So it's hard to know. Like, it's fluid. It changes moment to moment. While I'm fully vaccinated, I am still concerned about long-term impacts of this vaccination. And it was days after I got vaccinated that I had the nerve pain that landed me in the hospital. And for standard of care, there's still tons and tons of medical research that's in PubMed that has not been introduced into medicine. I heard it takes like 17 years for that to be introduced into medicine. So like the brain-gut axis affecting mental health is still not well used, even though it was in research for like 10 years. So it's very fluid, and it's very hard to have standard of care when there's a lack of dissemination of research. And I do think it's very important for doctors not to totally disregard common sense and offer bleach, which I am not sure if they do. I know Trump did, but I don't think doctors do. But I think a lot more research needs to be done about the effects of these vaccines and risk versus benefits. And some populations can't take these vaccines, and that needs to be acknowledged that the risk versus benefit is not safe for that population. That's it. Thank you.
Thank you for your public comment. Up next here, we have Laura Powell. Laura, you should be receiving a prompt on your end. Nope, just lost Laura Powell. Next up here, we have Susan Lauren. Give me a second. Let me try Laura here again. Hold on. There you go, Laura. Looks like you got that
Laura
prompt.
Powell with Californians for Good Governance. We oppose AB-2098 because it violates the First Amendment rights of doctors. The constitutional problem can't be remedied by tweaking the language of the bill because it's baked into the DNA of the bill. The purpose of AB-2098 is to restrict speech based on its content, and our Constitution simply does not allow such a broad infringement on speech, even if the speech is considered false, and even if the intent of the law is compelling. The mere potential that the law could be applied in a way that chills speech renders it unconstitutional on its face before it's even enforced. This bill can't be salvaged because if you were to strip away every unconstitutional element, what you would be left with would duplicate existing law. So what would the bill actually accomplish? It would discourage conscientious doctors from expressing themselves freely. To quote the U.S. Supreme Court, regulating the content of professional speech poses the inherent risk that the government seeks not to advance a legitimate regulatory goal, but to suppress unpopular ideas or information. Doctors help patients make deeply personal decisions, and their candor is crucial. Throughout history, governments have manipulated the content of doctor-patient discourse to increase state power and suppress minorities. Professionals might have a host of good faith disagreements, both with each other and with the government on many topics in their respective fields. The best test of truth is the power of the thought to get itself accepted in the competition of the market. And the people lose when the government is the one deciding which ideas should prevail. And from another case, the remedy for speech that is false is speech that is true. This is the ordinary course in a free society. The response to the unreasoned is the rational, to the uninformed, the enlightened, to the straight out lie, the simple truth. So because AB 2098 is unlikely to withstand a constitutional challenge on First Amendment grounds, and because the damage it would cause to our core principles is not worth any potential benefit to the public health discourse, I urge the board to withdraw
30
its
seconds.
support for this bill. Thank you.
Thank you for your public comment. Up next here we have Susan Lauren. Susan, you should be getting that request on your end.
Hi. I didn't listen to the discussion. I was offline, and someone called and said they're talking about misinformation and disinformation, so I'll just say in 1 minute, if we're going to focus on those things, then we need to focus on them for everything, not just what someone wants to pick out as their pet project. We know the plastic surgeons flagrantly disregard the truth, and they are giving misinformation and disinformation out as they have been doing for decades. And it's had really significant long-term health for the people that get it done, and it affects all their families. You know, there's a woman that calls occasionally, Susan Liu, who talks about her mother who was killed by Leslie Moglen way back in 1996. Nothing has changed. So I want this to be included with misinformation and disinformation, but not to the point where people don't have free speech. I do believe in free speech. Thank you.
Thank you for your public comment. Up next we have Renee.
But aside from that, I'm also
Renee, could you start over? Your introduction got cut off there a little bit.
You got it. Sorry, my name is Renee Rogers, and I'm on the board of California Parents United. But aside from that, I'm also a parent and a member of the public that you all serve. And I want to remind you that these bills affect the public as much as the associations have a say. At the end of the day, you're there to protect the public. So let me explain to you what these kind of bills have effect on the public. What this bill will do is essentially limit doctors from giving the right standard of care, even if it's a small percentage that needs something that is outside the standard of care. These doctors are afraid. They are limited by their insurance companies. I have personally seen the letters threatened by the licensing boards should they speak against writing the medical exemptions outside of what has been considered law as standard of care. We have attorneys threatening them, saying, if you continue with the treatment method, you are threatened with liability. Stop doing it. I also want to remind the doctor who spoke, and although I have sympathy for the cases that he's treated, I want to tell you guys a story about a young girl in the Bay Area. Her name is Mila. You can find her on YouTube. She went to a doctor she trusted. Her college in Walnut Creek, DVC, required her. She was a 16-year-old who graduated early. She went to go be a surgeon. She went to college. Her college required her, in order to take her labs, to get an unapproved vaccine that was the standard of care for our country. A 16-year-old walked in, got her vaccine, and within 5 minutes was taken by ambulance. And after seeing 7 specialists, who, by the way, mind you, prior to this, was training for triathlons. She was a dancer, and now is wheelchair bound with seizures. And let me remind you, you know what her standard of care was? Psychosomatic symptoms caused by lockdown. The standard of care. And we have one doctor that is even willing to treat her because of the limits of what the medical boards have put on our doctors. And continuing to push this you are lowering, you are reducing the standard of care for the public that you all serve, and continuing to limit doctors and doing the
30
research
seconds for me.
and doing the research and finding what is really helping these patients. If you have not seen what this injury has done on such a severe level, and the consensus in the community is they're psychosomatic and they have no treatment available to figure out how to fix these, limiting their speech and their way to practice medicine is going to completely eradicate the ability to get to the end solution. So I urge you guys to, you need to not back up this bill. We are nowhere in this place or ready for this.
Thank you for your public comment. This time I don't see any additional requests in queue.
All right, we'll bring it back to the board. Any further comments or questions before we take a vote? All right, I would just make a sorry, Dr. Ganadev.
Yeah, just want to comment on that. The newer treatments, even if they are not standard yet, but when we go through the process, there are experts on both sides. There are experts who can prove that this is a upcoming treatment which is not below the standard. So that is the concern some of us have, but the way we discipline doctors prevents that more on 99% of the time, because if we find a right expert who can justify that treatment the doctor provided, which is not in the medical literature standard yet, because medical literature continuously changes. So that protection is there. I just wanted to point out that it doesn't prevent people from taking on the newer treatments.
And just before we proceed to the vote, I just, I guess a concluding comment that, of course, I support the goals and sort of the objective of AB 2098, but also from my perspective, there really is no better use of our collective time than making sure that the public and our consumers in California have access to factual, scientifically grounded information. That is, I believe, the objective of this bill. I think it gets to, the heart of our mission, and I do think it's our responsibility to counter disinformation and misinformation that is in the public domain, especially as it medical misinformation and disinformation, and I'll continue to work to advance that. So with that, Ms. Moriarty, please call the roll.
Yes.
Dr. Hopkins?
Yes.
Dr. Ganadev?
Aye.
Mr. Brooks?
Abstain.
Ms. Lubiano?
Yes.
Mr. Rue?
Yes.
Dr. Thorpe?
Yes.
Dr. Tsai?
Yes.
Mr. Watkins?
Yes.
Ms. Lawson?
Yes. Thank you.